Hello students, I am Tanmay Dev and welcome to Sanchoita. In this lesson, you can learn to take dictation of the legal matters. Today's passage is a part of the judgment of the High Court. Speed will be 120 words per minute. Total words 656. Readback and transcription are two main important factors of stenography. For this, you can turn on subtitle button. Knowing meaning and outlines of important words also help you to gain speed and accuracy in stenography. So, after the dictation, you should try to read back your script and do transcription. After the dictation, you will get meanings and outlines of some important words and the full passage. Now, be ready. I will start the dictation after the countdown of 5. 5, 4, 3, 2, 1. Start. These two appeals arise out of orders pertaining to the same property. APO 248 of 2014 arises out of the final order passed on a writ petition challenging an order of the municipal commissioner as to the nature of use of the property. APO 415 of 2015 arises out of an order annulling the consequential assessment order on the ground that the nature of use as determined by the municipal commissioner had already been set aside by this court. The matter pertains to a building in the Alipur area allegedly let out for marriage and like functions. A disgruntled one-third owner of the property complained to the corporation regarding the use of the building by the first respondent, which claims to be two-thirds owner of the property and seems to be in possession thereof. There is no dispute that the building was shown as a commercial building and its annual valuation was determined on such basis. However, for a commercial building to be let out for marriages and like functions, permission is apparently required from the corporation and the annual valuation of the building would stand enhanced on the basis of its use. Following the perceived inaction on the part of the corporation authorities, the act upon the complainant's grievance that the relevant building was used for marriage purposes without obtaining appropriate permission or paying appropriate taxes thereon. A petition was instituted in this court under Article 226 of the Constitution, which culminated in a division bench of this court passing an order in December 2003 for the municipal commissioner to give a hearing to the complainant and the first respondent hearing and decide on the nature of use of the relevant building. It appears that some hearings were held, but when the municipal commissioner passed a final order, the first respondent herein was not represented. A further writ petition followed in this court on the ground that the first respondent herein had no notice or knowledge of the date of hearing finally fixed by the commissioner before passing the relevant order. Such writ petition succeeded on February 18, 2014 on the observation that the notice for the relevant date had not been issued to or received by the first respondent hearing. However, the petition was not disposed of by the order dated February 18, 2015, since the commissioner was required to indicate further dates when a hearing could take place. For reasons which are difficult to fathom, affidavits came to be filed in the matter and ultimately the petition was disposed of on June 17, 2014 by confirming the order of February 18, 2014, APO 248 of 2014 is the appeal from such order of June 17, 2014 by which the order of February 18, 2014 was confirmed. WP 2007 of 2005 was filed by the first respondent herein challenging the assessment of annual valuation made by the hearing officer for the relevant building, though the corporation was not represented when the order impugned dated August 26, 2015 was passed. The single bench took note of the fact that the assessing officer's assessment was based on the nature of use of the property and the municipal commissioner's order as to the nature of use had already been set aside by the order dated June 17, 2014. Upon it confirming the order dated February 18, 2014, in such view of the matter, WP 2007 of 2005 succeeded and the assessment order was set aside. The corporation is in appeal against such order by way of APO 415 of 2015. Since the case made out was one of breach of the principles of natural justice, and it is evident that the first respondent herein was not represented on the date when the municipal commissioner passed his order as to the nature of use of the property, it may do well to require the municipal commissioner to consider the matter afresh, particularly since there has been a long passage of time since the previous order was passed. Stop writing. This same dictation passage also available at 80 and 100 word per minute. Check dictation number 40 and 41. Now I am showing you some important words outlines. This is part 1. This is part 2. Now, the meaning of some important words. This is part 1. This is part 2. Now the full passage. This is part 1. This is part 2. And this is the final part. Thanks for watching. Through like, dislike, share and subscribe, you can encourage or criticize my work. Take care.